So good afternoon to everybody who's joined this webinar. Welcome to the most recent in our series of Foundations webinars. And today we're going to be looking at the thorny issue of termination. So I'm Dominic Jones, a partner in the construction and engineering team here at Mills & Reeve. I'm joined today by my colleagues Iain Murdoch and Jastinder Samra. Iain is a principal associate with a great deal of transactional experience and a knack for neat drafting solutions to capture nuanced commercial agreements. Jazz is a construction disputes specialist. She covers a broad range of contentious and dispute avoidance work, including where termination of contract is an issue. So before we dive in, regular watchers of the webinar series may recall that we discussed termination in the context of construction contracts not very long ago. In fact, it was in June last year that Jazz, who's here with us again today, along with Martino and Alison, other colleagues from the team, looked at the key principles relating to termination under contractual machinery and for repudiation at common law. Now, that session is recorded and can be found on our website and on our LinkedIn page and on our YouTube channel. And there will be a link to it on the set of slides that get circulated after this session. So we're not planning today to go back over the ground that was covered in that previous session. Instead, we want to move the discussion on a bit with reference to more recent developments in the case law and some situations that we're encountering on live projects. By way of format, I'm going to start with a summary of a couple of cases that have been heard in the High Court over the last year, and Jazz is then going to explore some scenarios that gave rise to two further disputes before the TCC, focusing on notice requirements in JCT contracts. Iain will then look at the termination procedures provided for in the NEC4 form, which until relatively recently have seen less judicial scrutiny. And we aim to leave 10 to 15 minutes or so at the end of the session. So that's for questions and answers. If there's anything you'd like to ask, please use the Q&A function, which should be live on your webinar screen. And we'll then do our best to pick up as many as we can at the end, while still keeping to the hour time slot. Now, I should say before we dive in that I've had a reminder recently of how disruptive termination of a contract can be. So on a large scheme that we've been working on, works were nearing practical completion when the contractor unfortunately became insolvent. And that, as anybody who's been through the experience of contractor insolvency will know, through a pile of considerations around termination of the contract, calling on a performance bond, obtaining consent from key stakeholders, including funders and prospective occupiers, and the practical matter of finishing off the works. So a very timely reminder for me of the importance of getting termination right there. But without any further delay, let's get stuck into the meat of today's discussion. So as I've said, the slides will be available afterwards in the Q&A we've talked about. So I'm going to start off with a couple of cases that have been heard over the last year. The first is Struthers and Davies. And this was a claim relating to defective and incomplete works brought by homeowners, the Struthers, who we can call Gavin and Stacey because those were in fact their names. And the claim was against their building contractor, Alistair Davies Building, and the contract administrator, although the claim against the contract administrator was settled before the trial. And the main issue for our purposes today related to the manner in which the claimant had sought to terminate the building contractor's employment. And hopefully you will see on the slide a timeline appearing. And here it is. So the contract was entered into on the 31st of March, 2015, and it provided for a contractual completion date of the 10th of August that year. the works were in significant delay, and by the 10th of August 2015, the contractor had ceased carrying out works on the site. Now, the contract terms were based on the Reeve building contract form, and the termination mechanism will look familiar to those who know that form of contract, and indeed it's very similar to what you'd see under a JCT form. Here, what was required were 2 notices for termination in order for termination to be effected where the contractor was in material breach of contract or had failed to proceed regularly and diligently with the works. So first, a notice of intention to terminate was to be issued by the contract administrator. And if the breach specified in that notice was not remedied within 14 days, then the employer was entitled to give a second notice to terminate the contractor's employment under the contract. Now, on the facts of this case, both notices were given by the employer, the claimants. The first, ostensibly on the 23rd of December 2015, and the second on the 11th of January the following year. Now, the court held that the first notice, the notice of intention to terminate, was not valid as a contractual notice. While the contract didn't say that that notice could only be given by the contract administrator, the court agreed that termination clauses are to be construed strictly and found that here, the effect of the contractual wording was that the notice had to be given by the contract administrator, and the fact that it had been sent by the employers was fatal to its validity. The judge commented that there were sound reasons for requiring the first notice to come from the contract administrator rather than the client. There were also issues around the proper service of the notices. So it wasn't clear from the evidence that the requirement for 14 days notice, clear notice, had been satisfied. So that contractual termination was ineffective, invalid. But the court did find a way to come to the Strithers' rescue. It identified a litany of failures by the contractor, including a refusal to purchase materials for the works, taking materials that the employers had paid for and using them on a different job, failing to progress the works, and in fact, confirming that the works would not be progressed until another job had been finished. So on that basis, the court concluded that the contractor was in repudiatory breach by the 10th of December 2015, or at least if not by then certainly by the 11th of January. And in those circumstances, the employer's notice of the 11th of January took effect as acceptance of the contractor's repudiation of the contract, entitling the employers to terminate the contract and to recover consequential damages. So 2 key takeaways from that case. First, I think it emphasises the importance of serving notices in accordance with the contractual requirements. So here, as we've seen, contractual termination was not valid because the wrong party had given that initial notice. And second, I think it's fair to say that in these circumstances, the claimants were fortunate that the contractor's breaches were particularly egregious, and allowed the court to pretty readily find that there had been repudiatory breach. If that had not been the case, the invalid attempt to terminate in accordance with the contractual machinery could have meant that the employers themselves had repudiated the contract, entitling the contractor to accept that repudiation and to claim damages itself. So I now move on to the second case that I wanted to look at, which is Optimares and Qatar Airways. And this case arises from a series of contracts entered into between the parties for the design, manufacture, and supply of business class and economy class seats by Optimares Qatar Airways. Now, in March of 2020, having already missed the first set of delivery dates, Optimares served notice of excusable delay in performance, citing COVID-19 and the Italian government's response to the pandemic. On receipt of those notices, Qatar served its own notices, exercising its rights to terminate the contracts at will, terminate for convenience. And the dispute centred on the contractual construction of the provision that should be appearing on your screen now. The court's review of this wording served to emphasise a few fundamental tenets of contractual construction. In particular, even where contractual arrangements are weighted in one party's favour, the court should look to the natural meaning of the words used, especially where the parties are sophisticated commercial entities who, as here, negotiated with the assistance of skilled professionals. So, to put it another way, it's not the court's role to rewrite a contract to assist an unwise party. And in this case, as we'll see as we walk through the wording, Optimares suffered the consequences of being the unwise party. So I want to just pick up on three issues of construction that the court addressed looking at this provision. First, there was a question around whether the existence, separate from this clause, the existence of another provision entitling the parties to terminate where Optimares was in excusable delay, prevented Qatar from using its right to terminate for convenience. The court read the provision and held that the language of the termination for convenience provision was clear and unambiguous in giving Qatar an unfettered right to terminate at will. So these two provisions in the contract coexisted, and it was up to Qatar to choose which clause it wanted to rely on. They each had different notice provisions, led to different consequences, and so there could be foreseeable scenarios in which each of the clauses may have been preferable. Second, the court considered whether the right to terminate that arose in this provision was qualified by any other provisions of the contract. In particular, an express duty of good faith that arose. Now, I'm not going to go into the detail of good faith provisions in contracts, which could be the subject of its own webinar. But for present purposes, I'll just say that the court considered that this wording at the start of the clause showed that the parties did not intend the right of termination to be disapplied or fettered by any other provisions, notwithstanding anything to the contrary contained in these provisions, these conditions. The court also commented that the good faith clause on its terms related to the performance of the parties' responsibilities and obligations, and noted that the right to terminate was neither a responsibility nor an obligation, so it didn't fall squarely within the parameters of the good faith provision. Third, the court had to consider the financial consequences that flowed from termination for convenience. And it held that where the contractual mechanism was followed, so the giving of the notices required by the contractual machinery, then the contract provided the sole remedy, and Optimares had no entitlement to claim reliance damages or other damages at common law. Specifically, the words "without incurring any liability" meant that Qatar would not be liable for the consequences normally flowing from termination, and would only have to pay the purchase price for shipments completed at the date of termination. As there had been none on the facts of this case, no sums were due for payment. So instead, Optimares had to repay to Qatar all sums that had previously been paid under the contract. Now, this may seem a particularly harsh outcome for Optimares, and may it serve as a reminder to contractual parties that the courts will only look to the principle of commercial common sense to aid contractual interpretation where the natural meaning of the words of the contract are not clear or leave room for interpretation. And where the express words are clear, as was the case here, then those words will not be rewritten by the courts, however detrimental to one party they may seem. So on that chastening note, I'm going to pass on to Jazz to take you through some further situations that the courts have had to grapple with recently.
Thanks, Dom. So I will discuss some of the key principles that Dom has already touched upon relating to the process and procedure of contractual termination within the context of the JCT. I will do this by way of two case study examples where the employer is seeking to terminate the JCT contract. In my first case study example, the parties entered into an unamended JCT Standard Bill Contract 2016. The contractor substantially suspends the works, and as a result, the employer is seeking to terminate the contractor's employment due to the contractor's failure to proceed regularly and diligently with the work. In light of this, and to put this into effect, the contract administrator validly serves the first termination notice, but the contractor's failure continues for a period of 14 days after receipt of the first termination notice. It continues to suspend the works. Within the 21 days of the first termination notice, the contract administrator then serves a second termination notice by hand at the contractor's registered office address. Now, my question to you all is whether the second termination notice is valid or not. This should, just to assist you whilst you're thinking about that question, the relevant contractual provision relating to the second termination notice, and I'll paraphrase that now, is if the contractor continues a specified default for 14 days after receipt of the first termination notice, the employer may, on or within 21 days, serve a further notice to the contractor terminating the contractor's employment. I'll give you a couple of minutes just to think about that clause and to answer my question. And then the answer should pop up on my screen. Okay, great. Just moving on to my second slide. So 63% of you said yes and 37% said no. The correct answer is indeed no. And that's because the unamended form requires the employer to serve the second termination notice and not the contract administrator. And those were the adapted facts of Monaco Living Limited, which is where at adjudication, the contractor successfully challenged the effectiveness of the second termination notice. And it did this because, and the basis of this was because the project manager served the notice and not the employer. And the employer was, as a result, found to be in repudiatory breach of contract. This case illustrates just how important it is to get all of this right, not only just to avoid, or I say just, but to avoid satellite litigation, but also to inadvertently being in repudiatory breach of contract and incurring losses as a result. Just moving on to my next slide and to my second case study. The second case study is similar background facts in that both parties enter into a JCT Standard Bill contract. The employer again is seeking to terminate on the basis that the contractor fails to proceed regularly and diligently with the works. The contract administrator again serves and validly serves the first termination notice, and then on day 15, the employer serves the second termination notice by post and email. and then after firing off that email, excludes the contractor from site on the same day. It's important to note at this point that under the unamended form, notices cannot be validly served by email. And if notices are served by post, then they are deemed to be received on the second business day after the date of posting. As a result, the employer is therefore putting in effect the second termination notice 2 days before it should have. Just moving on to my next slide, these were the adaptive acts of Thomas Barnes and Sons. And as an aside, that case is really wide-ranging, with judge making points and determining points relating to common law termination, around the weight to be placed on witness and expert evidence, and also around concurrent delay. But for our purposes, the High Court held on this point here that the employer was not in repudiatory breach of contract, despite putting in effect the second termination 2 days before it should have. And the High Court gave two main reasons for this. And the first point it made to support its decision was that the claimant had, in that case, ceased all meaningful activity on site and was therefore realistically not in any position to move forward with the works. And as a result, this meant that there was no adverse impact upon the contractor in being removed from the site 2 days earlier than it would have had to leave anyway. So 2 days being the date under which the notice, the second termination notice, would have been valid under the contract. This case may assist in defending parties against a claim of repudiatory breach of contract in circumstances whereby the mistake is somewhat technical and there is no adverse impact on the other party. But really, I would again emphasize the points around the importance of complying with the contractual provisions around termination to avoid having to defend against being inadvertently repudiatory breach of contract and the satellite litigation that can result from all of that. So I will now pass on to my colleague Iain to pick up on termination in the context of NEC.
Thanks very much, Jazz, and thank you, Dom, for earlier on. And as Dom said earlier on, if you do have any questions that you'd like us to try and answer during this session, please do use the Q&A box that should be on your screen to do that, and we'll endeavour to get to them. So I'm the third of three, and I've deliberately taken a slightly different approach because, as Dom remarked in his introduction, although there are plenty of cases now, I think it's fair to say, that refer to and mention the NEC suite, there are still relatively few that pick up termination specifically under that. So my example is going to draw more on recent experience of negotiations of contract, and what I've put up on screen and talked, just to give you a moment to look at it, is using the ECC, the engineering construction contract, as an example. The termination table, it's an adapted version of that because I've put option X11 in because parties often do have that option in their ECC, and it sets out who can terminate, the reasons for termination, the procedure for termination, and the sums due, all set out in the context of the NEC4 suite. And slightly different versions of this termination table appear in the different versions within that suite. So if you go on to the next slide, you'll see I'm going to walk you through the reasons and the procedures and the amounts. So what are those reasons? Well, insolvency is a reason. Insolvency is important. Dom mentioned in his opening remarks how that's a real life situation that many of us would have encountered on projects at main contractor, subcontractor, or even client level. But one thing that I'm going to highlight later on is the insolvency regime set out in the NEC termination clauses needs to take account of the local law. Even if you're in England and Wales, make sure you've picked up recent changes or more recent changes, and that you're comfortable that the insolvency regime that's referred to actually fits with the jurisdiction that you're working in. But that's where the NEC starts, and it's a good place to start. Then you move on to reason, the group of reasons number 2, breach. Again, I'm deliberately summarizing the position here, but if there's a contractor breach, the general position is that there could be 4 weeks for the contractor to remedy that breach, and the contractor needs to be given that opportunity. And the main cause of a client breach perhaps is non-payment, and the NEC specifically allows for termination for non-payment, but gives quite an extensive period for that to have had to pass by 13 weeks. So again, just to be aware of the sorts of periods that are set out, and then thinking back to those JCT and broader cases we were talking about, what that would mean for a contractual regime and when notices can be served and when termination can occur. The NEC then also covers reasons relating to the operation of law. If the project stops work, and again, different reasons there, if work has been stopped as a result of something that the client has done versus work has had to stop as a result of something the contractor has done. And then it picks up force majeure. Now, the NEC doesn't use those words. What I can swiftly on a slide describe as force majeure is much more extensively described in the NEC than it might be in other contracts. It's almost any unexpected act. It has to be genuinely unexpected, but it's broad, and yet you won't find that clause if you were to search through the NEC looking for force majeure specifically. And then there's a reason relating to corruption. X11 I mentioned when I had the table up on screen in the previous, it's often summarized as termination for convenience, but the NEC does refer to it as termination for other reasons. So again, I think even in that sense, you need to be careful to give it a reason if you're using X11 and terminating for convenience. So that's a whistle-stop tour through the reasons, which the NEC refers to as its sort of R1, 2, 3, and 4, or in some of the other forms using the full word reason. Here are the procedures, which the NEC cunningly refers to as by P numbers as opposed to R numbers. But I didn't want to start there, because I think one thing that you could do, and those of you who are more familiar with the NEC will already know this, you could make the mistake of reading through the NEC from the termination table onwards and get to your P numbers and think that that's all you need to read. But the procedures are broader, and this is where the notice regime kicks in. That it's different under NEC4 compared to JCT. And if either party wishes to terminate, then they have to notify the other party and the project manager or service manager if it's a PSC. And it's up to the project manager to certify that termination. And that is set out before you get to the termination table. If there is a certification, that also triggers under NEC4 the obligations around final assessment of any sums due, and that then links into the amounts that I will come on to in a minute. But a quick tour through the Ps. The procedures are that the client may complete the works, the contractor leaves site, but is required to assign the benefit of its subcontracts. The client may use contractor equipment to complete the works, or the contractor leaves the site and removes its equipment. And again, I am very happy being supportive of the NEC philosophy that there's a balance in this contract and that things have been set out in a particular way for a particular reason. But there may be good reasons for any particular project why you might need your own procedure to apply. And adding a P that sets out what might need to happen on termination is a very valid Z clause choice, whatever your views are on how much you think the NEC should or shouldn't be amended to suit an individual project. But as you can see from these Ps listed, these procedures listed, it's important, again, if you are making changes or thinking about what's going to happen, to realise that you can't just list them all if you're making changes to the termination table, because they are in some senses mutually exclusive. If the client is using contractor equipment, the contractor can't be also at the same time required to leave site and remove equipment. And that's why not all of the Ps apply in any of the Rs, not all of the Ps apply to any of the reasons, and you need to see what consequences follow from the different reasons in the table. So having mentioned the reasons, having mentioned the procedures, let's move on to amounts. And I think it's fair to say that the NEC has a relatively extensive baseline position under A1, that sums will be due to the contractor under that default position. And in particular, I think it's fair to say that on some of the sorts of projects that the NEC ECC is used for, clients may want to limit the costs that can be incurred under A1 in expectation of completing the whole of the works. If you're working on a very long project, it may be inappropriate to pick the bill up for things over the whole of the life of the works. But then from the contractor's point of view, it may also be important to highlight that certain fixed costs are being incurred almost from day one or early on in the project, and be sure that you can pick up those costs entirely appropriately if everyone knows what's going on, if the worst was to come to the worst and the project wasn't going to proceed. A2 picks up the defined cost of removing equipment from site. A3 allows for the additional cost to the client of completing the works. And A4 means that the fee percentage would be applied to the remaining cost of works. And if we cast our mind back to the table, or you're familiar with the termination table, again, from that list, it will be immediately apparent, I'd hope, to those of you familiar with the way that construction contracts work, that not all of those amounts are going to be payable in all circumstances. So again, it's entirely appropriate to think that you may need to add a project-specific amount that relates to your project that does or does not kick in particular reasons or in a particular scenario. And then I would just mention, because again, it's easy to overlook if you are just rushing, as it were, through, that you also need to be aware of your main options. They can have an impact on exactly how it's calculated. The main option A says that you don't have to group specific things together when you're assessing costs at termination in the same way as you would group them together when you're assessing normal month-by-month payment applications. And option C and D provide for the contractor share, the pain share, gain share, to be assessed. That's not something I'm going to dwell on, but again, just to sort of bring together those secondary options, X11, and the main options, A, C, and D, in your thinking about NEC4 termination. So a deliberately whistle-stop tour there. If I can ask Dom to put up my next slide, then I have an older case and no poll, you'll be pleased to know, to draw to your attention here, because as we've both said, there are plenty of cases now on NEC. The courts are used to dealing with NEC contracts, but there are still fewer cases on NEC in total than JCT, and that's especially true of termination. So 2017 is quite a long way back to go compared to the cases that Dom and Jaz have mentioned to you, but there is a case on NEC termination, or at least that's one of the things that the court needed to look at in ICI and Merit. Yes, it was an NEC3 rather than NEC4 contract, but in the context of what we're talking about today, I think it's a clear judicial statement not to ignore the termination table and not to ignore the NEC mechanism in just the same way as you'd be loath to ignore the mechanism set out in the JCT. And in that case, the court found against a client that alleged repudiation by a contractor because the client's notices didn't follow the NEC3 processes. They didn't refer to a reason from the table for termination, and they didn't follow the contract's rules. So the client's alleged repudiation by the contractor just didn't hold water in that case. And so I think it's fair to say I'm going to round up my thoughts with just some thoughts I presaged a couple of times when I was going through. But if you can put the next one up, please, Dom. It's well, what might you consider in the drafting? What's coming across our desks at the moment on NEC projects? I mentioned the need to update the insolvency references for England and Wales or whatever jurisdiction you're working in. I've mentioned the fact that I think it's absolutely legitimate to always think whether your project needs its own amounts, its own procedure, or its own reason for termination. And perhaps there are some things that aren't fully addressed in NEC4, and this is just partly to do with the way that the contract is written in its deliberate and knowing choice not to have extensive cross-referencing in the way that we're used to in JCT contracts. But are these exclusive remedies on termination? And is it very important for this project to know exactly what sums will be paid and that those are the only sums? And what are loss of profits claims going to look like? Is it limited to the fee and only payable in the circumstances that the fee is payable on termination, or is it something else? Could that be an important point for your project? And where there are express limitations, whether those are set out in secondary option X18 or are bespoke, what is the relationship between those limitations of liability and any sums payable on termination? And then maybe a few other things to think about. And again, this might tie back into whether you need your own amounts, procedures, or reasons, but are there knock-on effects of any termination on your projects? Are there specific losses that might flow under a third-party agreement? Are there specific things that a contractor has had to pre-order, or a specific piece of equipment that the contractor can afford to buy to complete the works but would be so significantly expensive for them to buy that they can only afford to buy it to complete the works? What are the knock-on effects that might happen? And do consider that sort of wider project specific scenario. Is there critical intellectual property rights? Is there some document, piece of information, or regulation that the project needs to follow that you also need to track through to the consequences of termination, and perhaps requiring a specific P to address? So, these are the sorts of things that are coming across my desk at the moment. It's not quite the same juicy disputes as Jazz is seeing day to day, but that's a summary of where some of the live issues that are coming across. So I'm going to hand back to Dom, and he's going to take us through any questions.
Great. Thank you, Iain. Thank you, Jazz. We do have a few questions that have popped up into the Q&A box, so we will run through some of those. And while we're doing so, anybody else who has got burning questions, I think the Q&A will remain open. So do put your questions up, and we'll look to cover those. There was what, as the two of you were talking, actually, another thought occurred to me, which was maybe worth just mentioning before we get into the Q&A, which is that a number of the cases we've seen recently also looked at the question around the quantum of damages that were recoverable in relation to remedial work that had to be carried out post-termination. And I think it was Thomas Barnes' case that Jazz looked at, and also the Struthers case that I talked about, where in both of those circumstances, the courts looked to the reasonableness of the remedial work that had been carried out. In the Struthers case, what had happened was the extension had been demolished and rebuilt in order to address the defects that had been identified. And the contractor ran the argument that that course of action wasn't necessary in order to deal with all of the defects, and that the employers hadn't mitigated their losses by doing that could have taken a more proportionate approach, and so should only be entitled to recover the costs of works that were in fact needed to correct defects. Consistent with the approach the court took in the rest of that case, they had no sympathy with the contractor's position there, and it was important that the employers had taken expert advice. The court decided it was reasonable in those circumstances for the employers to rely on that expert advice. And the fact that the costs that had been incurred were not the minimum possible didn't make the course of action that had been adopted unreasonable. In that case, the court was prepared to allow pretty much the full claim for damages, notwithstanding the fact that it was more than the minimum costs, say, that had been incurred. So let's look at some of the questions that have been coming in, and maybe to kick off, there's a point around whether the cases we've talked about demonstrate a trend in the courts looking to try and assist parties who may have failed to comply with contractual terms, whether that there's a movement away from a previous position. Jazz, can I fire that one over to you in the first instance, just to get your thoughts?
Yeah, of course. So Thomas Barnes, I think, is a really extreme example of where that happened, in that despite the employer actioning the second termination notice 2 days before it was strictly allowed to do so under the contract, there were real reasons in that case that the court gave to support the fact that that was allowed to happen, and that there was no adverse impact on the contractor. I don't think that will ordinarily be the case, and it's unlikely to assist parties in the wider circumstances. So I think in terms of the contractual provisions, that they are there for certainty, and they will no doubt be looked at in any adjudication and by the court in great detail as to whether or not they have been complied with. But Thomas Barnes exists and supports those extreme examples whereby there is no adverse impact on the other party, and the court will take that into account in its decision and make its decision accordingly, I think.
Yeah, I'd agree with all of that. I think, in fact, the cases we've looked at tend to confirm the importance of getting the contractual mechanisms right if you're going to rely on that procedure. And as you say, sort of extreme examples, and it would be dangerous, I think, to rely too heavily on falling into a similar fact pattern. So always try and get the notices served correctly by the right people in the right order in the right timeframes. Iain, one probably for you, and maybe I'll wrap two questions together that have come in. The first is regarding NEC4 and JCT. Can the client terminate their contract if they've found a modern slavery case in the contractor's supply chain? And I wrap the next one in mainly because it's sort of a comment that you might have a view on, and it also relates to the NEC forms of appointment and other standard forms. The point is that they are usually so heavily edited that they are no longer the form they purport to be. And I thought that might link to the modern slavery point, because that is something that often is the subject of amendments.
Yeah, I agree. I mean, perhaps start at the specific and work out modern slavery, where I'm seeing it dealt with, is being dealt with either at framework level, where you where that on the client side, you're requiring the contractor to, if they want to play a role in the framework, to agree to comply with modern slavery legislation, and often at that level where there are a client offering repeat work, to not only comply with legislation, but also maybe go beyond the minimum level of compliance, report regularly back to the client, and take those other proactive steps to manage it. But linked with those obligations, then at that framework level comes an obligation to comply, and a right for a compliant, if there isn't compliance, to terminate not only the framework, but also to terminate individual call-offs under the framework, which in some of the ones that I've been dealing with are on NEC terms, whether that's a PSC or an ECC, or in some instances an ECSC form. So sort of, again, it gives you a bit of consistency in the different forms if you're handling it at that framework level. But it is a ground where I would prefer to include a short and specific reason if required, rather than rely on the generality of the NEC drafting. And the modern slavery position in the JCT, again, I would suggest that if that's a ground that the parties want to specifically allow for termination, then it's probably best to say so. Now, that leads neatly to the second part of your question. Well, if it's always probably best to say so, does that mean that the terms end up being very different to the ones that are printed in the standard form? Well, I can only say that, yeah, well, that can happen. And sometimes there's a reason for that. And sometimes even very extensive amendments are very much project specific. But it is also perfectly possible and appropriate to look for a balance of what does the standard form cover in the way that the parties need it to cover, and then what changes are suitable for the local jurisdiction, are suitable for the project, are suitable for the fact that it's in the public sector, are suitable for the fact that the employer is in the public eye and needs to really manage its reputational risk on things like modern slavery that really, really matter to them. Well, then those are the sorts of amendments that should be contemplated and can be included in a way that is consistent with the standard form, rather than a way that cuts across the standard form. And certainly, I'm sure we've all got examples in our day-to-day practice of seeing amendments that are made in a way that remains consistent with the standard form, compared to others that just sort of seem to land like a spaceship from outer space, rather than fitting in with the form.
Yeah, thank you. Is it maybe it's fair to say that the standard forms tend to take a little while to catch up with legislation? So we now have in the JCT and in the NEC standard forms references to breaches of the Bribery Act 2015 as grounds for termination, and it may be that the Modern Slavery Act will follow in due course. And I think there's talk about the JCT being updated 2023-2024. That may be something that comes in, but one of the purposes of schedules of amendments to the standard forms is to pick up on more recent statutory provisions, and this is perhaps an example of that, where detail might be required. And on the more general point about amending NEC contracts and moving away from the principles that are meant to underpin them, I suspect there is a sizable category of NEC contracts which have been amended to make them operate much more like another form of contract, or to move away from the risk profile that the NEC starts off with. And perhaps the point really is around parties thinking through for their project how they want to operate the relationships, how they want to manage the program and the interfaces between the various parties and stakeholders. And if adopting an NEC form, that comes with a philosophy behind it. And if that's the philosophy that the parties are comfortable with and want to follow, then there's no need to adjust that philosophy materially. There may be elements of it that need to be made more bespoke to address the specific requirements of a project and the way in which the project program is to be managed, for instance. But often those wholesale amendments arise because people choose an NEC contract but don't actually want to use that philosophy, and that's perhaps one thing that we see.
Yeah. We saw one other question, didn't we, Dom, come in about the FIDIC. So maybe just a quick thought on that is that it's not a form that comes up anything like as regularly in my practice day to day as NEC or JCT do. But my short answer to the question that's come in there is, whichever standard form or non-standard form you're using, I think the general principles that we've picked up on flow through all of those. And certainly the case law I can think of in England and Wales where there was a FIDIC form, it did follow the same thrust that we have talked about in those NEC and JCT cases, and it wasn't handled differently because it happened to be on a form that was more suited to international or more used for international contracts than the more local ones that we've mentioned.
Yeah, agree. Abrascon is the name that brings to mind.
It went all the way to the Court of Appeal, didn't it? So that's.
I think it was on the old FIDIC form though. So
I think so. It's before the
2017 version. Yeah.
Yeah, I agree. That's my memory as well.
There are a number of other questions. We'll try and get through a few of them. I think there was one further comment about NEC forms. That is the same point we've addressed. So here's another question. Where termination for default has been carried out incorrectly, so I think that means contractual termination mechanism not implemented properly, but the contractor has been in default. So on the facts, there's a breach of contract, but the procedure hasn't been followed properly. Will the court take into account the default when considering the contractor's claim for repudiatory breach? Jazz, can I fire that one over to you again? So we're I think it's similar to the one you thought about previously.
So where the contractor has been in default, will the contractor take into account the default when considering the contractor's claim for?
It might be the employer's claim for repudiatory breach.
Yeah, exactly that. So the court will consider the contractor's default and whether so I think the short answer to that is yes, the court will consider all of the facts and matters relating to termination and whether a party has been in repudiatory breach inadvertently or otherwise, and whether that then has been accepted by the other party, or whether a party has deliberately terminated the contract and has followed the notice provisions and therefore validly terminated the contract. Don't know if you have anything else to add to that, Dan. Sorry.
No, I agree. I think the cases we talked about actually, one of the reasons that the courts were able to find that repudiation had occurred and were able to come to the assistance of the claimants, even though they failed to follow the contractual requirements, was because it was pretty clear that the contractors in those circumstances were in breach of the contract terms. I think one of the points on Thomas Barnes was that the consequences of operating the contractual machinery or common law termination were substantially similar. and so where it was clear that the contractor was in breach and wasn't proceeding with the works, the fact that there was a 2-day delay, clearing them off site 2 days early wasn't a reason that the employer was found to be in repudiatory breach. Yeah, I can see
I think that must be right, Dom. But I think the other thing that we'd always add from that, again, our practical experience and from the reading of some of the older cases, which we deliberately didn't rehash today, is if you can put yourself in a position where you spend that extra day, which can feel like an eternity, or even that extra hour, checking and double checking that you've got the right notice, you've referred to the right ground, you've sent it by the right party and by the right method, you are in a so much more solid place than if you realise the day after you've sent something that actually, if only I'd said a different ground, or if only I'd sent that by post rather than by email, or any of the other many if onlys that can occur, because there are quite a few cases where there were facts out there that a court could have perhaps taken the opportunity to take into account, and they didn't. And I can't think of the names of the cases off the top of my head, but there are cases out there in England and Wales where a notice has referred to a particular ground for termination that didn't in fact apply. There was another valid ground for termination available, but the courts didn't come to the rescue because that ground was never relied on and was never communicated to the other party. So I agree with everything that Dom and Jazz have just said, but there are, to use the phrase that I put on the slide, lessons from history that go the other way as well. So I think probably, Dom, I've crashed into some of your concluding remarks as the clock ticks where it is, but maybe that's a neat segue back to you, isn't it? But there we go.
Very good, thank you. There's a nice concluding comment in the Q&A box, actually, which says the advice from our head of legal is to avoid termination if at all possible. And that probably is consistent with the remarks that we've made. It's often referred to as the nuclear option, and there are circumstances where it can't be avoided, and in those circumstances, I think the point that hopefully is coming across clearly is make sure that you're very clear on the grounds, and you follow the procedural requirements as closely as possible. So I think that concludes the discussion on the Q&A. Thank you all for sharing questions. We'll just wrap up by mentioning that the next webinar in the Foundations series is on the Building Safety Act and updates over the last 6 months. So we have an erudite panel of speakers to talk to you then. Please join 26th of April between 4 and 5 again. And as promised at the outset, there is a link on the slides that will be circulated to the previous webinar relating to termination, which gives you the introduction that we then picked up on. Request for feedback on today's session and any other topics that you'd like to hear more about, so that we can address those in future Foundations webinars. And I think that brings us to I clicked a link somehow. That brings us to the end of the session. So as the slide says, thank you for joining us, and we have wrapped up almost on the stroke of 5 p.m. So thanks to Iain and Jazz, and to all of you for joining, and we'll wrap up there.